क्या केवल विधायकों के संख्या बल के आधार पर किसी मूल राजनीतिक दल और उसके ऐतिहासिक चुनाव चिन्ह पर कब्जा किया जा सकता है? माननीय सुप्रीम कोर्ट में आज शिवसेना के नाम और धनुष बाण चुनाव चिन्ह विवाद को लेकर एक बेहद ऐतिहासिक और आक्रामक कानूनी जंग देखने को मिली। उद्धव ठाकरे गुट की ओर से पेश हुए वरिष्ठ अधिवक्ता कपिल सिब्बल ने माननीय सुप्रीम कोर्ट के सामने कई तीखे संवैधानिक तर्क रखे। उन्होंने सीधे तौर पर एकनाथ शिंदे गुट को मिले चुनाव चिन्ह को तत्काल फ्रीज करने की मांग की और दलील दी कि अगर विधायी बहुमत को ही असली पार्टी मान लिया गया तो यह हमारे लोकतंत्र और दल बदल विरोधी कानून का सबसे बड़ा मजाक होगा। इस बेहद संवेदनशील मामले पर चीफ जस्टिस सूर्यकांत की अगुवाई वाली माननीय सुप्रीम कोर्ट की 3 सदस्यीय खंडपीठ ने भी कई गंभीर और दूरगामी कानूनी टिप्पणियां की हैं। आखिर आज देश की सबसे बड़ी अदालत के भीतर कपिल सिब्बल ने कौन से बड़े सवाल उठाए? पीठ का इस पूरे विवाद पर अब क्या रुख है? आइए समझते हैं आज की इस मैराथन सुनवाई की पूरी इनसाइड स्टोरी।
Page 5, Malaz, submission 13. Therefore, the Election Commission allots the symbol of a recognized party to a candidate only on the basis of the prescribed communication by the political party's leadership as available on the records of the Election Commission of India. Consequently, the original political party of a legislator that sets him up as a candidate is necessarily to be represented by the political party's leadership for the purposes of the 10th schedule. And I've shown you all what is Form B and all that, as well as paragraph 1 explanation B, B explanation to the 10th schedule. Then as per para 6 of the 10th schedule, the only question to be determined by the speaker in proceeding for disqualification is whether a member of a house has become subject to disqualification under this schedule. There is no other inquiry to be made. Therefore, by entertaining a plea that the political party's leadership is not in accordance with the party constitution and consequently not representative of the political party is wholly beyond the scope of the 10th schedule. To hold otherwise would allow delinquent legislators, see the mischief, to dispute their political party's leadership after having relied on it to get elected to the House. Such an interpretation is totally contrary to the scheme and structure of the 10th schedule. Then, anybody, any breakaway faction or in the legislature can say, I don't accept you as the leader. As they said, I don't accept you as the leader. I will make myself as the Mukhya Neta and I will have my own whip. I don't accept you. That's not contemplated on the 10th schedule, especially when you got the benefit of the very party under which you were elected. So in Subhash Desai, I just want to point out para 119 of Subhash Desai. I've already quoted it here. If I may read from here instead of taking your lordship through the judge, no point. To hold that it is the legislative party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators could rely on the political party for the purposes of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. But this is very important. In fact, the 10th schedule guards against precisely this outcome. The whole purpose of the 10th schedule to ensure that the sin of defection is nipped in the bud. You will now give it, mushroom it. Allow it to mushroom, if this kind of interpretation is given. And now this actually determines the issue. How the speaker can go contrary to it, we don't understand. And this is page 76 of the judgment compilation. Then, number 2, the legislature party can never be treated as the political party itself under the 10th schedule. The 10th schedule provides for disqualification of legislators from being a member.
Just for the information of the members of the bar, no other matter will be taken up. It's a part of the matter. It's continuing. So the rest of the vote is discharged.
The 10th schedule provides for disqualification of legislators from being a member of the House when they have conducted themselves in a manner that amounts to voluntarily giving up membership of their political party, or when they vote contrary to the directions issued by their political party. The term legislature party finds mention in the 10th schedule only at two places. I've already quoted that, one B. Mills. I won't read that again. Defines legislative party. Para 4, which deals with defense of merger, that the relevance of a legislature party under the 10th schedule is only at the time when the defense of merger is set up. That's not the case here. It is pertinent to state that the term legislature party also finds place in the erstwhile para 3, which provided for the defense of split. Now, my contention is in the absence of a split, there is no defense available to them. On the 21st of June, there is no defense available to them because split is not accepted. If you allow this to happen, you will bring back split through the back door and say this is a defense available. So the only defense they could have had was that I am the political party. That's what was decided against them. They can't in any case, because on 21st of June, they never claimed to be the political party, except to the extent they say, we are majority of the legislators, therefore we are the political party. Well, that's not available to them. Thus, a group of legislators, howsoever large in number, is bound to follow the directions of its political party, else they will be subject to disqualification, barring the limited exception of merger. The distinction between the political party and the legislature party and the limited relevance of legislature party in the context of the 10th schedule was noticed by Subhash Desai. Political party at para 109 cannot, I've read it, Maras, cannot be conflated. That's the paragraph already read before your lordships. Contention of the respondents that political party and legislative party is inextricably intertwined is erroneous for the following reasons. Parliament in its constituent capacity was conscious of the necessity of not allowing anti-defection laws to stifle intra-party dissent and the freedom of expression of legislators. It was with this objective that the defenses of merger and split, which was later omitted, were introduced. The 10th schedule confers legitimacy to the actions of the legislatures, which would otherwise lead to disqualification if a substantial number of legislators, 2/3 in the case of murder and 1/3 in case of erstwhile provision of a split, disagree with the political party. The next is important. The 10th schedule recognizes the independent existence of the legislature party to the limited extent of presenting a defense to the actions of the legislature, which would otherwise have amounted to defection. And that defense in this case is not available because that defense is only a para 4 defense, which is a merger defense, given the page of the judgment. It is pertinent to state that a political party is a permanent body registered with the Election Commission in terms of 29A. It may or may not contest elections, or even when it contests, it may not return any successful candidates. On the other hand, a legislative party is merely the group of legislators who at a particular time comprise the successful candidates belonging to the political party. Thus, by its very nature, a legislature party is temporary and its existence is coterminous with the term of that house. It has no existence beyond the term of that house, Mullahs. Whereas a political party registered has an existence, Mullahs, much beyond, Mullahs, the elections. So that's another, Mullahs, inherent distinction between the legislature party and the political party. If a majority group of legislators are held to represent the political party itself, the actual permanent organization outside the house would lose all significance. It would just lose significance, Mullahs. And the legislators would get a free hand to defy their political party for extraneous considerations. This is the sin, Mullahs, that needs to be nipped in the bud. This would place the political party and its workers and supporters at the mercy of the machinations of opportunistic legislators, an outcome that the 10th schedule is designed to prevent and punish. The Honorable Speaker in the impugned judgment has treated the majority group of the legislators as the Shiv Sena political party itself, and thereby upended the structure of the 10th schedule. Now let's come to the 2018 party leadership. Malas, the irony is you base your legitimacy on an illegitimate act. And that illegitimacy continues for years. And then you will ultimately say to the court, now that it has continued for years, give me legitimacy. It's like Malas, an unauthorized construction on government land. You construct, the government does nothing about it. Then at some point in time says, this is government land. You say, but I have been there for a long time. So this Malas, unauthorized construction of the 10th schedule can't ever, Malas, be to their benefit. It is submitted that the Shiv Sena political party leadership was duly reflected in the letter dated 27th of February, submitted before the Election Commission of India. Shri Uddhav Thackeray, as the Paksh Pramukh, was elected leader of the party. Further, Shri Uddhav Thackeray enjoyed overwhelming support in the party leadership. This was duly demonstrated before the Honorable Speaker through affidavits of support sworn by 9 out of 13 leaders and 24 out of 33 deputy leaders. Malas, your lordships may have a quick look at this document, Malas. This is at page 21 of the compilation, Malas, the convenience compile, final convenience compile. That's the
21 letter of 27.
Yes, I'm reading. Yes. Show me that. Where is it? Yes. Page 21, Malas. Yes.
Shown in the beginning also.
That's right. That's right. I just want Malas to refresh. Organizational elections been conducted on 23rd January at Mumbai, and the information regarding designation, that's in terms of 29A. Malas. So I'm sorry, Malas, I go back to my commissions. And then, Malas, and then at page 170 to 187 and 188 to 235, we, Malas, inform the commission that this is the support enjoyed by us. On the other hand, the respondents group neither pleaded nor produced, this is important, nor produced any material before the Honorable Speaker to demonstrate the support enjoyed by Eknath Shinde amongst the political party leadership. Now, Malas, I'm talking about 19th of July. But that's the time when he had to, Malas, demonstrate that support. Para 27. Therefore, the Honorable Speaker was bound to recognize Uddhav Thackeray in his capacity as Paksh Pramukh to be representative of the Shiv Sena political party. In Subhash Desai, the Constitution Bench duly acknowledged the communications actions of Uddhav Thackeray in his capacity as Paksh Pramukh to be representative of the Shiv Sena political party. Malas, that's para 128, I'll just read it. On 21/6, that's the letter I just showed you, there was no material on record before the Deputy Speaker for him to doubt the resolution of the Shiv Sena Legislative Party dated 21/6, appointing Ajay Chaudhary as the leader of the party. It was dehorsed the political party, or that two factions of the party had emerged. The resolution was signed by Mr. Thackeray in his capacity as party president, much like the resolution appointing the whip and leader in 2019. This makes it evident that Mr. Thackeray issued the communication on behalf of the political party. Thus, the decision of the Deputy Speaker recognizing Ajay Chaudhary as the whip and in place of Eknath Shinde is valid. This is what he says. Even otherwise, it is respectfully submitted that the entire exercise of requesting the Election Commission to provide a copy of the party constitution, which has been submitted to the Commission to hold that the 1999 election constitution is the relevant constitution of Shiv Sena, is completely unlawful without jurisdiction. The details of the communication with the Election Commission are recorded in the impugned judgment as follows. As I read this, he says, as per the Honorable Apex Court, if both the factions have submitted different versions of the constitution of the party, then in that case, what has to be taken into account is the constitution which was submitted to the ECI with the consent of both parties before the rival factions emerged. Before recording further conclusions, I find it imperative to reiterate that pursuant to the initiation of these disqualifications, the Maharashtra Legislative Party had, by letter dated 7th June 23, requested the Office of the Election Commission of India to provide a copy of the party constitution, memorandum, rules, whether known as such or by any other name, of Shiv Sena political party, which have been submitted to the Election Commission in India and stand effective as on 21st of June. It is also pertinent to mention that in the said letter, it was specifically requested to the Election Commission of India that copies of all subsequent amendments, if any, to the Constitution be also provided. In response to the said letter, the Election Commission, by letter dated 22nd June, provided a copy of the Constitution and rules of Shiv Sena as available on the records of the Commission. Further, with respect to amendments, if any, to the said Constitution, the Election Commission requested the Legislature Secretariat to refer to the order of 17th February passed by the ECI, case number.
This is the symbols order.
This is the symbols order, Malaj, where Election Commission recognizes both sides, Malaj.
Have relied on this
And they say they have relied on this to 2018 Constitution. It is respectfully submitted that in the present case, there was no occasion to consider the Constitution submitted to the Election Commission, since both parties had relied on the same version of the party Constitution, being the 2018 Constitution, which was appended as Annexure 18. Well, they appended it in their reply. And then before the Speaker, Malaj, they appended this very Constitution. And then at a later point in time, filing an additional affidavit, they say this was by mistake. This is a lawyer's mistake. Having appended the Constitution.
39 separate replies.
And they filed 39 separate replies, Malaj. This in 2018, because each was separate, Malaj. So each of them mentioned the 2018, provided the 2018 Constitution. So 13 advocates, Malaj, made a mistake. 39 advocates made a mistake. That may also be a conspiracy, Malaj, to make a mistake together. It is respectfully submitted that in the present case, there was no occasion. No, I've read that. Then let us kindly see item 4, para 30. In Subhash Desai, the Honorable Constitution Bench has duly considered the legality of the rival resolutions dated 21/6, one by the political party leadership replacing Eknath Shinde with Ajay Chaudhary as group leader, and the other by respondent MLAs reaffirming Eknath Shinde as group leader and replacing Sunil Prabhu with Bharat Gogavale as chief whip. Both resolutions were specifically before the Honorable Constitution Bench in the writ petition that was decided. So once the Constitution Bench has rendered a decision, how can the Speaker decide contrary to it? After considering the issues, the Honorable Constitution Bench held the Honorable Deputy Speaker's decision that dated 21st June, accepting the resolution communicated by Uddhav Thackeray to be valid. On the other hand, the Speaker's decision on 3/7, accepting the Shinde's group resolution, was held to be invalid. However, the resolution passed by SSLP on 22nd of June brought to the attention of the Speaker that it was passed by a faction of the SSLP. Thus, the Speaker, by recognizing the action of a faction of the SSLP without determining whether they represented the will of the political party, acted contrary to the provisions of the 10th schedule, the 1986 rules and the 56 Act. The decision of the Speaker recognizing Shinde as the leader is illegal. Now, whereas the Speaker says just the contrary. On the ground that I look at, there is no constitution. I look at the 1999, leadership structure is inconsistent with it. Therefore, I will discard all that. And therefore, we are left with the legislature and he is the political party. Even if you are left with the legislature, he can't be the political party. That's decided by the Constitution bench. Despite the aforesaid, based on the perverse logic that majority legislators represent the Shiv Sena political party itself, the Speaker decided to recognize Eknath Shinde as the validly appointed leader and Gokavale as the validly appointed whip. Whereas this is, I'll just read it because I don't have to go to the document. I've quoted it here. Once it has been held that the Shinde faction was the real political party, it is no longer possible to accept the proposition that a whip appointed prior to the emergence of the faction previously would continue to hold the power, especially when he did not belong to the real political party. It could be argued that his removal was by a resolution of the legislative party and not by the political party. But this is easily answered when it is understood that the recognition of the Shinde faction as a real political party has resulted in severing the umbilical cord that connected Sunil Prabhu to the real political party. If this were not so, then the legislatures would have no choice but to follow the direction of any whip, which might not reflect the will of the political party, or might even be contrary to the intent or directives issued by the political party. Such a whip could act with impunity against the will of the political party, as well as the legislature party, on the specious assumption that his original appointment was validly made. In view of my finding that the Shinde faction was the real political party when the rival factions emerged, and in view of the resolution of 23rd of June passed by the Shinde faction, I have come to the conclusion that Eknath Shinde was the validly appointed leader of the Sena political party, contrary to the Constitution bench. In view of my findings that the Shinde faction was the real political party when the rival factions emerged, and that Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022, I further conclude that Bharat Kagavale was validly appointed. Again, contrary. It is respectfully submitted that the Speaker's decision is in the teeth of the categorical findings of this bench, the Constitution bench in Subhash Desai, and liable to be set aside. Then, Maharaj, what are the undisputed facts, Maharaj? Maharaj, I just want to make one thing clear. I am not going to go into any documents provided by me because questions have been raised about those documents, Maharaj. I am not interested in, Maharaj, trying to prove to your lordship that these are genuine. I will go by the undisputed facts that both sides agreed upon and then make my submission. So what are those undisputed facts? Kindly see, Maharaj, on the left-hand side, the table, 21st of June, 26th of June. Para 35, the following undisputed facts are sufficient in law to attract disqualification. While camped together in same hotel in BJP-ruled state of Gujarat, Surat, on 21st June, respondent MLAs passed a resolution of Shiv Sena legislature party seeking to change the chief whip appointed by the political party and reaffirming Eknath Shinde as their group leader as a direct affront to the political party. Further, they marked a copy of this resolution to the Honorable Governor, who had no role whatsoever in the matter, demonstrating their intent to topple the government. Maharaj, I want to show this document to your lordships, where they show, Maharaj, they're a copy to the governor. Kindly have a look at that. That's at page 117, Maharaj, of the convenience compilation.
117?
117 of the convenience compilation. I just want to show your lordships that resolution. That's the governor.
23.
Work करेंगे. Yes.
This is a legislature party resolution.
Yes. Now, Maharaj, this is undisputed, this document. It's a legislature party resolution. So we go by that. It's their document. That's dated 21st of June. Resolution of the meeting of Shiv Sena, Maharashtra Legislative Assembly. And it's marked to the governor. Then there's signatures below, and it's marked to the governor at page 123. What's the relevance of that? How is a resolution of the legislative party marked to the governor? What role does the governor have to play? because that's how the governor called for a floor test.
Why they say held that to be illegal?
And Subhash Desai held that action of the governor to be illegal. So all that the speaker has said is entirely contrary to the findings of the Constitutional Bench. So I just wanted to show this to your Lordship, Mullahs. Yes, now come back, Mullahs, too. So this is undisputed. These two acts by themselves, they are liable to be disqualified. Then, Mullahs, back at page, at that table, Mullahs.
Second.
Page 11, second table. Then the undisputed fact on 22.6. Respondent MLAs refused to attend the meeting of the Shiv Sena Legislative Party on 22.6 on the instructions of the party president by disputing the authority of the chief whip of the political party to issue a notice. Who was the chief whip? Sunil Prabhu. He called for a meeting.
They gave a reply saying.
They gave a reply, you have no authority to call for the meeting because we have our own whip, namely Gogavale. This is an undisputed fact. That itself, this is the third fact which makes them liable for disqualification. Then come the next, that is 22.6 onwards. Respondent MLAs traveled from Surat to Guwahati and stayed in the same hotel. It was reported in the news that the logistics of the respondent's stay at the hotel were closely overseen by an MP and 3 BJP ministers close to the Chief Minister of Assam, and BJP Yuva Morcha leaders were seen to be staying in the hotel in turns. Eknath Shinde also released a statement that his group had the backing of a national party. Now, they may dispute it, but I think this court has enough experience to ferret out and infer the reality of the situation. They formed the government on the 30th with the BJP. And they traveled to Surat and then to Guwahati. That itself is telling. And you don't have to produce evidence to show that.
BJP rule states.
I think now you know, I know, they know. Now this answer. According to us, this also should be undisputed. Anyway, next. That's why I made no comment there, Melissa. Then kindly 28.6. The leader of the opposition, Devendra Fadnavis, met the Honorable Governor and requested him to direct the holding of a floor test. The Honorable Governor then called for a floor test relying on the resolution of 21.6. That's undisputed. That itself will result in disqualification. The next. On 30th June, Eknath Shinde, with the support of the respondent MLAs and the BJP, met the governor and staked his claim to form the government in Maharashtra and was sworn in as chief minister without reference to the political party. Undisputed fact. Then on 3rd of July, respondent MLAs admittedly voted for Rahul Narvekar, the BJP candidate for the speaker's election, despite being another candidate, Shri Rajan Salvi of the Shiv Sena. At that time, there was no question of another political party. Now, that's the 2.1b, undisputed fact. The others are 2.1a. This is 2.1b. Then 4th of July, all respondent MLAs admittedly voted in favor of the government formed by Shiv Sena, by Shinde, with the support of the BJP in the confidence vote on 4.7, undisputed, again 2.1b. So it is respectfully submitted that the actions of the respondents resulting in toppling of the MVA government, of which the Shiv Sena political party was a part, and the formation of a new government with the support of the opposition BJP is a classic case of political defection in violation of the 10th schedule. This honorable court has in several decisions held that the mere meeting the governor with the opposition party amounts to violation, but this is held in Rajendra Rana, amounts to violation of para 2.1a. In the present case, the respondents have not only supported the opposition party in toppling the duly elected government formed by their party, but rather they have themselves formed the government with the support of the opposition party. Reference is invited to the decision rendered in Rajendra Singh Rana. Para 48. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to act of voluntarily giving up membership of the party on whose ticket the said members had got elected. Clearly, from the conduct of meeting the governor accompanied by the General Secretary of the Samajwadi Party, the party in opposition, and the submission of letters requesting the governor to invite the leader of the opposition party to form a government, as against the advice of the chief minister belonging to the original party to dissolve the assembly, an irresistible inference arises that the 13 members have clearly given up their membership of the BSP. No further evidence or inquiry. This is what I'm asking your lordships to infer. No further evidence or inquiry is needed to find that the action comes under paragraph 2(1)(a). The very giving of the letter to the governor, requesting him to call the leader of the opposition to form a government by them, itself would amount to the voluntary giving up of membership of the original party within the meaning of paragraph 2. And then, Malad, in Srimat Balasaheb Patil, is another, Malad, I think it's three-judge judgment of this court, Karnataka matter, we did it together. Says the speaker in the impugned order has taken note of the surrounding circumstances, including the conduct of the petitioners from February 2019 onwards. It ought to be noted that sufficient opportunity of hearing was accorded to the petitioners herein, who had also filed their responses. It ought to be noted that while notice dated so-and-so, and a meeting of the INC Legislative Party was called on 18/1/19. The notice stated that the members must compulsorily attend the meeting, otherwise action will be taken against them under the 10th schedule. The petitioners did not attend the party meeting on 18/1. Admittedly, the petitioners also refrained from attending the subsequent general body meeting on 16/2, as well as the assembly session. The resignations were submitted by the petitioners nearly 4 months after the disqualification petition had already been filed. Similarly, Malaj, when Sunil Prabhu asked them to attend the meeting, their answer was, you have no authority to. So it clearly falls within this dictum here, Malaj. Then para 38. Notably, while disqualification petition 1 to 16 were filed on 23/6 and disqualification petition 18 was filed on 27/6, the petitioner had filed an additional affidavit on 23/9, bringing on record the subsequent facts, including Eknath Shinde meeting the governor, staking claim to form the government, and taking oath as the chief minister on 36. The respondent MLAs supporting the government formed by Eknath Shinde in the confidence motion on 4/7, and many respondent MLAs serving as ministers in the government led by Eknath Shinde. The filing of the additional affidavit was objected to by the respondents. We filed that and they objected, on the basis that the petitioner was seeking to amend the pleadings and bring in fresh facts. At that time, I didn't know the facts, they only came to be known later. That did not have a bearing on the alleged time and event when the members allegedly incurred disqualification. It was also claimed that the new pleadings would become part of the petition and the respondents will have to be given time to file additional affidavit. After careful consideration of these submissions, the additional affidavit dated 23/9 was categorically taken on record by the speaker, White order dated 2010. The facts mentioned therein thus became part of the pleadings and required consideration. Due to this, these facts subsequent to the filing of the disqualification petition were also considered by the speaker in the impugned judgment, even though it was eventually held that the facts did not lead to the conclusion that the respondent incurs disqualification. Therefore, Maharaj, we say it is respectfully submitted that instead of appreciating the legality of the above actions in a holistic manner, the speaker in the impugned judgments has considered some of the contentions in an isolated manner and held that the same be not established on erroneous technical grounds. The main contentions based on the undisputed acts of the respondents have either not been dealt with or rejected on the ground that the respondents themselves represent the political party. So what does he say, Malad? We said respondents became incommunicado. He says, how can I decide that question? Because we haven't put forth any. The reason was, Malad, that they went to Surat and they went to Guwahati. Where was the question? But anyway, we won't go into that, Malad. As I told your lordships, I am not on our acts. I am on the undisputed facts. Second is respondents remained absent in the SSLP meeting held on such and such. That is because they say Shinde is the real political party, which I have already addressed your lordships on. Respondents' deliberate absence. He says they are the political parties are not relevant. Respondents' resolution purporting to change the whip. They say they are the faction which is the real political party. Respondents acting in concert with EJP. They say that's a mere allegation. No inference can be drawn. Anti-party, anti-coalition statement. They say newspaper reports. Whereas in these matters, courts have relied upon newspaper reports because you can't lead evidence. Eknath Shinde meeting the governor, he said Shinde faction was the real political party. Therefore, it is respectfully submitted that the undisputed facts on record clearly establish that the respondents are liable to be disqualified under 21A. Then, Millers, under 21B, I've already, Millers, told your lordship the undisputed facts. I won't repeat them, Millers.
Para 44.
Then kindly come straight away to paragraph 44.
Speaker's reasons for the
Speaker's reasons for the 21B, Millers.
It's
No.
sections.
Yeah, para 44.
Sections.
Yes, right.
Para 44.
This now? Where is para? This?
Finding. These are the findings.
Well, it's just the finding of the speaker in the second table. Shinde faction was the real, but we've already said all that. We've said all that. Let's not repeat it. Service of whips, we've said all that. Petitioners group had not complied with. Now, Millers, this is important. Item 3, petitioners group had not complied with the requirement of Rule 3.5 of the members Maharashtra Legislative Disqualification Rule. Millers, 3.5 says that within a certain number of days, you can, Millers, condone the act of disqualification. So he says, since you have not said that I don't condone it, therefore I assume that you have condoned it. This is 3.5. That's how the logic is. As your lordship knows, under all these rules, within 20 days or so, if the party writes that he has incurred disqualification, but let's condone it, I don't want you to deal with it. In this case, I did not write. So he says, the fact that I did not write shows that I have condoned. But I filed disqualification for this. So obviously I have not condoned. So this is the logic of the speaker. Well, there's a very, very flight of his imagination is really very compelling. Whips did not state that whips did not, item 4, did not state that in case they are not followed, it would result in. Item 4, he says, whips did not state that in case they are not followed, it would result. They say the whip should have stated that in case they don't follow the whip, it will result in disqualification. Since it did, we did not state it, therefore, how can it be disqualified? Then comes to 5. No whip can be issued for election of the speaker since the candidate was not set up by any political party. When we are the party and they are in the house, whip will be issued. This is our candidate. This is the political party's candidate. This is also completely wrong, Millers. Then 6. Gogavale was recognized as the whip on 3/7/2022. Legislators who acted as per this whip cannot be faulted. But we are challenging the very appointment of that whip. This logic is also, Millers, something that needs to be. Then what else? That's it. Millers, I just want to read 2 paragraphs, Millers, in Kyoto. Last document is Kyoto, Millers. Which other paragraph? The sin of defection. Sin of defection.
In the judgments compilation,
I'm sorry?
in the compilation,
Yeah, we've given it, Millers, just a new one. I'm sorry.
It's not there in this compilation.
I'm
It wasn't
sorry.
there in.
Yes, yes. Which is the paragraph on this sin of disqualification? Sin of disqualification. You can mention it. Para 122, Millers. Another one. Yes, yes. Para 140, page 725 of this. No, sorry. It starts at page 86 of this compilation, Millers, and at 160, 160, Millers. Just add these two paragraphs and then I've done, Millers.
160.
160 page, paragraph 140 of this judgment.
140 on top.
Yes, top is that. My Lord Justice Mona just Bakshi have that. Kindly see Miller's para 140.
Potentially.
The 10th schedule was inserted in the Constitution by the 52nd Amendment, which came into force with effect from March 1, 1985, and is popularly known as the Anti-Defection Law. The statement of objects and reasons says that this amendment in the Constitution was made to combat the evil of political defection, which has become a matter of national concern, and unless combated, is likely to undermine the very foundations of our democratic system and the principles which sustained it. These are prescient words. So, my submission to your lordships is as a matter of interpretation. Please don't interpret it in the 10th schedule for allowing defections to take place. Because that's a sin. Karnataka judgment says the same. This amendment is therefore for outlawing defection to sustain our democratic principles. The 10th schedule contains 8 paras. Para 1 is the interpretation clause defining house to mean either House of Parliament or the Legislative Assembly, or as the case may be, either House of the Legislature of a state. The expression legislature party and original political party, which are used in the remaining paragraphs, are also defined. Para 2 provides for disqualification on ground of defection. Para 3 provides the disqualification on ground of defection is not to apply in case of a split, indicating therein the meaning of split. Para 4 provides the disqualification on grounds of defection is not to apply to a case of merger. Para 5 provides for the Speaker or the Deputy Speaker of the House of the People of the Legislative Assembly of the state, the Deputy Chairman and Council of States, or the Deputy Chairman of the state from the applicability of the provisions of the 10th schedule. And therefore, he says, Malas, at the heart of the issue is that the manner in which people violate the 10th schedule, the only defense is available under paragraph 3 and paragraph 4. Otherwise, make sure that you do not destroy the very foundations of our democratic process by encouraging, through an interpretation of the 10th schedule, defections that will take place. So if you say that, look, after 19th of July, he has got that much support, that's encouraging defection. Because when you are in power, this will happen. After 21st of June, this happened. Oh, but that's wholly irrelevant. In other words, Malas, you must freeze the event on the 21st of June and on the 19th of July. Anything that happens thereafter is encouraging defections, not dealing with the sin of defection. That's at the heart of the interpretation of the 10th schedule, Malas. And I pray to your lordship, it's my considered, Malas, opinion, and I plead before your lordship, Malas, to hold that Shiv Sena name belongs to Thackeray, to hold that the faction of Shinde cannot have the symbol. And the fact that they have enjoyed the benefit of that symbol is not a case of equity. It's a case of illegitimate use of a symbol. It should be frozen. If he can't have it, I can't have it, it has to be frozen. And the name belongs to me.
This is your alternate.
This is my alternate submission. You can't, well, he cannot create equity by doing something illegal from the inception. With those words, Mother, I'm deeply obliged. You've been very, very patient with me. I'm honored, Mother, to have argued this matter.
Thank you, Mr. Singh.
I'll show it. Let him do also.
But I'll be very brief, my lord. My learned friend has covered most of the topics. Lord, for the first 10-15 minutes, I'll deal with disqualification since your lordships are already hearing it. And balance, my lord, I'll devote to the symbol matter. Lords, I've put all my thoughts on my lord's paper, and I'm not going to read the written submission. Broadly, I'll indicate, my lord, what the points are as far as disqualification is concerned. My lord, obviously the first question, my lord, which I hand it over. Lord, which will be relevant is, why are we discussing the disqualification? Because the period is already over. And my lords, my learned senior colleague already hinted that, my lord, pursuant to a constitution bench judgment in Rana, and my lords, followed by a 3-judge bench in Srimant Patil, your lordship's court have already taken a view that, my lord, the final verdict regarding disqualification is only an ex post facto recognition of the fact of disqualification which has happened. Now here, my lord, the acts alleged have happened between 21st of June till 4th of July. So if your lordships are pleased to hold in our favor, then, my lord, the declaration would go back. So that's the first point, my lord, and I have, my lord, extracted the relevant submission, observations of the court. If your lordships are pleased to have, my lord, page 2 of my note. You've given the disqualification. Yes. Page 2 of my note. Submission A, the outcome of the present petition has a direct bearing on the symbol dispute. And, my lord, the relevant portion of the judgment in Srimant Patil, my lords, I'll just place that. My lords, that is in paragraph 6. In addition to the above, the decision of the speaker that a member is disqualified relates back to the date of disqualifying action complained of. The power of the speaker to decide upon a disqualification petition was dealt by a constitution bench in Rana. This court, reading the provisions of paragraph 2 and 6, has clearly held that the speaker has to decide the question of disqualification with reference to the date on which it has occurred. So this is the relevance part.
But can we declare him to be disqualified today?
Yes, my lord.
The speaker having not declared him disqualified erroneously or otherwise.
Yes, my lord. My lord, the submission would be this.
Because we are not an appellate body.
Yes, my lord. But ultimately,
Exercising judicial.
correct, my lord. Ultimately, my lord.
Decide quash an order.
Yes, my lord.
Order is illegal.
Yes, my lord.
But can we assume the role of the speaker and disqualify?
My lord, ultimately, my lord, the list was alive when we, my lord, filed the SLPs. And, my lord, the judicial review in.
Clear
Yes.
in what I
Yes, ma'am. Yes, ma'am.
if an order is challenged in judicial review,
Yes, ma'am.
and the order is found to be perverse,
Correct, ma'am.
illegal, we can set aside the
Yes,
order and remand the matter for fresh consideration in terms of the direction.
Your lordships have also said, my lord, in disqualification matter. Correct.
Going down the
Can
principle.
we assume the role of the speaker
My lords, in
and say that he is disqualified and would be deemed?
my lord, in all these cases, my lord, where disqualification, my lord, was ruled out by the speaker, when the matter came up in appeal, your lordships decided it and said, my lord, that he is disqualified. Lord, your lordships exercised power, my lord, of judicial review. And in 110, 111 of Kyoto, your lordship said that, my lord, judicial review is limited against the order of a speaker. If the order of the speaker is perverse, which we will demonstrate.
Restrictive role of
Yes.
a cassation court,
Yes, my lord.
unlike an appellate court,
Yes, my lord.
is to assume the jurisdiction of the court
Correct,
of
my lord.
justice.
Correct. But
So,
so therefore, my lord, the speaker's order, my lord, emanates as is, my lord, it's not, my lord, in the capacity of the, my lord, leader of the house. My lord, it is a tribunal. So therefore, my lord, when the tribunal has acted with perversity, I'll cite that paragraph, my lord, that your lordships will correct it in judicial review. If the speaker has failed in his
that order.
duty, my lord,
You-
and your lordships can also give the relief.
That is what we say.
Yes, my lord.
That we have no doubt in our mind
Yes, my lord.
that if the approach of the speaker is contrary to law, and
Correct, ma'am.
Mr. Sibal has argued before us
Yes.
very eloquently that Subhas Desai principles were
Correct,
not
ma'am.
considered or considered incorrectly. we are with him, we set aside.
Yes, my lord.
But can we say that consequentially we declare him disqualified?
My lord, the reason will be that, my lord, although the effective relief will not be there, because, my lord, under 194, my lord, the term of the assembly, my lord, is what is relevant. My lord, it will be a disqualification, a declaration will be given, my lord, but with no consequent relief.
No
Lord,
consequent relief.
Lord, even in, my lord, 356 matters, your lordships are aware. SR Bommai, my lords, was decided much after the, my lord, yes, my lord.
It's a much limited
Correct, my
area.
lord. But the declarations were given, but in view of the fact, my lord, that assembly elections were held. Yes, I'm
In
sorry.
fact, 356 is not even a comparable.
Correct, my lord. It's much higher, my lord. It's much
Much
higher.
higher.
Much higher. So this is, we are dealing with the tribunal's order, my lord.
Constitutional power
Yeah.
exercise, very limited area.
Correct, my lord.
Speaker is exercising quasi judicial power.
I'm grateful, my lord.
Doubt
Grateful.
in our mind,
Correct.
and we have also no hesitation
Yes.
to issue a writ of certiorari.
Yes, my lord.
The question is, can we issue a writ of mandamus and say that he shall be deemed to have been declared?
My lord,
this
once the declaration is given, my lord, your lordships will also clarify. I'm sorry.
military order can be given.
My lord, I am
Because
on this.
in doing that,
Yes.
we would convert ourselves from a court of review to a court of appeal from the order of the Speaker,
My lord, in
which
all
the
these,
Constitution did not provide to us.
my lord, in all these judgments, where your lordships have upheld disqualifications, where the speaker, my lords, had refused to adjudicate on disqualification, your lordships have disqualified them. Exercising, I'll make a chart, my lord, and give it, my lord. So that, my lord, my lord, as far as that is concerned, my lord, we'll give judgments and the paragraph number.
Just wanted
Yes,
to
my lord,
check
including,
because of
yes.
this unique factual situation.
Yes, my lord. But ultimately, my lord, if your lordships have the power to give a declaration, the fact that the term of the assembly is over.
Doubts.
Yes, my lord. So that,
There is no doubt
yes, my lord.
that we can caution and set aside the
Correct,
order, dismissing the
Yes, my lord.
disqualification.
Correct.
And say that it was incorrectly decided, wrong parameters, etc.
Yes, my lord.
etc.
Now, my lords,
Can we? The next thing is what?
On the
Yes.
resultant,
Yes.
my lord, the reason why I'm saying, my lord, even if your lordships are pleased to hold, my lord, that the,
Let's consider a situation,
Yes.
again, not very comparable.
yes, my lord.
In a disciplinary proceeding,
Yes.
someone is given disproportionate punishment. We can cost the punishment. Can we impose the punishment? We have to remand it again, consider, ask the disciplinary authority to pass appropriate order
Yes, ma'am.
in accordance with the direction.
Yes, my lord. But
Scope, having gone because of the expiration of the tenure, whether we can declare him.
my lord, even if, my lord, I bow down, my lord, to what is falling from your lordships, if your lordships are pleased to hold that, my lord, the disqualification petitions were incorrectly decided, my lord, let's assume that, then, my lords, it will have a definite bearing, my lord, on, my lords, the symbol dispute. Because in Subhash Desai, my lord, this very conundrum, my lord, which there are two parallel proceedings, my lords, one disqualification, one ECI. Will the ECI, my lord, be justified in, my lord, applying the test of legislative majority? My lord, the Supreme Court in Subhash Desai said they will not be justified. So therefore, my lord, yes, my lord. So therefore, even if your lordships are pleased to hold that the order is illegal, my lord, it will have a definitive impact on the symbol dispute. That's all I wish to say.
Amar,
Yes, my lord.
there is no dispute that Mr. Singh had legislative majority.
Correct, my lord. Correct.
But the question is, when he assumed legislative majority,
Yes.
did he remain the party?
Correct, my lord.
Remain the party.
Correct, my lord. My lord, as far as the disqualification is concerned, my lord, that question will be entirely irrelevant. Now, my lord, there are a few principles, my lord, in Subhash Desai which really answer this. My lord, those paragraphs I don't wish to point out, but please have a look at, my lord, I've made, my lord, a chart of what the principles are and with references to the paragraph numbers. I have placed it under 4 headings, my lord, in paragraph 8. If your lordships are pleased to have paragraph 8, my lords, at page 3. Not the first principle my learned senior colleague Milad has already dealt with, that the political party and legislature party are two different concepts. But one thing, my lord, if your lordships are pleased to turn to page 4, principle G, a legislature party cannot set up a candidate. Your lordships got that, my lord? That is, my lord, in 116.1. in page 4 of my note, my lord, in paragraph G on top, my lord. Page 4, my lord. Lordship got that. Now, my lords, this is relevant because, my lord, the Constitution 10th schedule, by a deeming fiction, my lords, in the explanation, clearly states who is the original political party. And that is, my lord, whichever party, my lord, has set that candidate as far as the election is concerned. So Subhash Desai is very clear that a legislature party cannot set up a candidate for election. If that be the scope, my lord, then the inquiry as to, my lords, whether the legislative majority can constitute the political party is entirely beyond the ambit of the 10th schedule, my lord. So that is point number 1. Then, my lords, kindly turn to the second set of principles. The purpose of symbols order and the effect of the decision under paragraph 15. Now, my lords, if your lordships are pleased to see in this, item C, the substance of the decision under paragraph 15 is which of the groups is the lifeblood of the political party. Now, this is very important, my lord, because your lordship's court felt that in paragraph 15, my lord, the essence of the dispute is to find out who really is the lifeblood of the political party. In that sense, my lord, that lifeblood is recognition of de facto state of affairs. So, my lord, the inquiry as to whether, my lord, the constitution is de jure, whether your conduct is de jure, etc., that can't be the test at all. Subhash Desai said you have to find out the lifeblood, who are in majority, who constitute the heart and soul of the party. That's one of the principles. Now, kindly see, my lord, the heading 3. Lord, this is what I was, my lord, attempting to submit. The potential for complications where there are simultaneous proceedings of paragraph 15 and the 10th schedule. Now, this is a heading in Subhash Desai, and the relevant paragraphs, my lord, I have cited. Scenario A, ECI gives its decision first, which has happened in our case. Scenario B, speaker gives its decision first, which has not happened. Now, kindly see, my lord, the next. If the faction which enjoys the majority in the House is disqualified after being adjudicated to be the political party, the very foundation of their claim, being the political party, no longer subsists. This is not a constitutionally desired outcome. So, therefore, in our case, my lord, where the disqualification has happened after the ECI, and, my lords, if your lordships are pleased to then hold that, my lord, this disqualification order is not correct, then the reliance by the ECI on the legislative majority, Supreme Court says it's not a constitutionally desired outcome. Then, my lords, D is extremely important. And where, my lord, the Election Commission has gone completely wrong. And this paragraph, my lord, is paragraph 157, 158. In such circumstances, it would be futile to assess the legislative majority in paragraph 15, and the ECI should look at other tests. So therefore, my lord, the entire foundation, as your lordships have seen, my lord, from that 101, etc., in the Election Commission's order, entirely goes, because Supreme Court says you cannot have legislative majority test when there are parallel disqualification proceedings. Then, my lords, kindly see E. The decision of the speaker and the decision of the ECI are based on different considerations and are taken for different purposes. Your lordship saw yesterday, my lord, that the speaker cites, my lord, Sadiq Ali and says, I will find out who is the party depending on legislative majority. Supreme Court says the tests are completely different. Then, my lords, F, the decision of ECI has a prospective effect. Lord, this is very thoughtfully, my lords, worded. My lord, the Supreme Court was conscious of the, my lord, difference in the nature, genre of proceedings as far as, my lord, the 10th schedule is concerned and the ECI, as your lordship, my lord, Justice Bagchi has been putting to us. My lord, the ECI proceedings under paragraph 15, my lord, is a proceeding of adjudication as to which of the rival factions constitutes the lifeblood of the political party. And my lords, pursuant to that determination, the political leadership of that party can change. So, my lord, the status quo can be altered in a paragraph 15 proceedings. But as far as, my lord, 10th schedule is concerned, it is only identification, my lord, of who is the political party at the relevant time. So there is a complete, my lord, difference, jurisprudential difference between paragraph 15 and, my lords, paragraph and 10th schedule. Then, my lords, the fourth heading. What are the principles which govern adjudication under the 10th schedule? This is Subhash Desai again. In cases where a petition is filed after the commission of prohibitory conduct, which is the 21A and 21B, the decision of the ECI cannot be relied upon by the speaker for adjudication of the disqualification proceedings. Then, my lords, if the petitions are adjudicated based on the decisions of the ECI, in such cases, the decision of the ECI would have a retrospective effect, which is contrary to law. Then, my lord, C is also extremely important. And, my lord, this I am going to devote a little bit of time. Lord, Supreme Court says when the prohibited conduct is committed under the 10th schedule, there is only one political party. And the speaker has only to determine prima facie who the party was at the time when the prohibited conduct is committed. So, my lord, that prima facie determination is not adjudication. The speaker here, your lordships have seen, has gone on, my lords, adjudicating whether the 2018 leadership structure is valid, invalid, whether it is in conformity with the 99 Constitution. Prima facie determination would only mean, my lord, that under explanation explanation a question of an adjudication. Therefore, my lord, there is a complete jurisprudential difference, and he has conflated, my lord, the paragraph 15 adjudication and brought it under, my lord's 10th schedule. Then, my lords, kindly see D. No faction or group can argue that they constitute the original political party as a defense. Now, this is very important. This is paragraph, my lord, 170. If, my lord, a legislature facing disqualification can have the defense that no, I constitute the political party, then all this, my lord, evidence comparing whether, my lord, the 2018 Constitution is on record, 99 Constitution, whether the leadership structure matches. But the Supreme Court says that in paragraph 170, I can place that, my lord. Just want me to place that. Paragraph 170, my lord, between placitum D and E. This will be there. Page 90, my lord. The question before this court is, what is the impact of deletion? I'm sorry. In Mr. Sibal's compilation, it's page 90. My lord. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both factions of the Shiv Sena, claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the Shiv Sena legislature party. However, no faction or group can argue that they constitute the original political party as a defense against disqualification. And then the court says, my lord, in paragraph 174 and 175, that the speaker has to do only a prima facie determination. And this, my lord, my learned friend has argued yesterday, this is in a case where both parties, my lord, have tried to amend the Constitution, have placed different versions of the Constitution before the ECI. There are different leadership structures. Then the question will be, who's the political party? That question doesn't arise in our case. Then, my lords, kindly turn to my lords E, which is again a prima facie determination. Supreme Court has said in my lord 3 places. I've given the paragraph numbers. Then, my lords, F is that portion of 175, where if rival groups submit 2 or more versions of the Constitution, the Speaker must consider the version of the Constitution which was submitted to the ECR. That question doesn't arise here. Then, my lords, G is extremely. Yes.
Come on.
Yes.
170 has to be read with 174.
Yes, my lord. Correct.
174 says,
Yes.
see the last
Yes, my
five
lord.
lines,
The determination is a.
to determine which of the members of the parties have voluntarily given up membership.
Yes, Lord.
It is necessary
Correct,
to first
Lord.
determine which of the factions constitute
Correct.
the political.
Correct, Lord. I was making, my lord, a nuanced point.
So when you see 170,
Correct, Lord.
you read 174
Correct, Lord.
together. 170 is in relation to split.
It also says there is no defense.
Why? Because
Yes, Lord.
split is no longer a defense.
Correct, Lord.
So who is the original political party?
Correct, Lord.
Who are the membership
Yes.
in legislative party?
Yes.
Does not matter.
Yes.
Because you cannot have a split as a defense.
That's right.
But when paragraph 2 is to be determined of voluntary given up of membership, then which group you claim or you allege to have voluntarily given up membership, whether they are the party, is something which
That is.
prima facie they.
That's the submission which I was making, my lord.
That's it.
That's
Because
the my lord nuanced point which I was
because
making.
you said that
There-
C is not correct. Prima facie it has to.
Yes, my lord. But a defense, my lord, can go beyond prima facie. Lord, defense can be that I have to adjudicate, Lord, the entirety, whether the 2018 Constitution is on record, etc. But in a prima facie determination, my lord, this is beyond, my lord, the scope of the Speaker's jurisdiction. That's the point, my lord, which I was making. Then, my lords, G is extremely relevant. ये 40 हो गए. बोल देना. Then, my lords, kindly turn to G. Speaker, this is, my lord, very categorical. Speaker must not base his decision on legislative majority alone and the structure of leadership.
The comment that 175 paragraph is a very interesting paragraph.
That's true, my lord.
First 10 lines for Mr. Call. Last 4 lines for you.
Paragraph also. Mr. Sibal's the last submission. You have a similar para in your submissions also.
That paragraph will require
Lord, according to us,
a deeper scrutiny.
yes.
You need whole general clause rejected.
Says rival constitutions have
Yes,
to be
sir.
considered.
But in our case, my lord, there were no rival constitutions. Yes.
In what context was
Yes,
Pence
that's
saying rival constitution?
Yes, no. No, it was an abstract, probably position of law, my lord, may not be relevant to the facts.
That is what we say. Paragraph 125 is 175. Very,
Yes, my lord.
you have to be very careful in
Yes,
reading 175. Last 5 lines are very clear.
yes.
That legislative majority
Cannot be looked at. And
cannot be given that importance.
primacy, my lord, primacy. Now, my lords, another sub facet of this. Lord, what was argued, my lord, in detail before the speaker was that, my lord, a speaker's proceeding is like a civil trial. And, my lords, I have to, my lord, put my case, my lords, beyond reasonable doubt, etc., as a quasi-criminal trial, etc. But that is now well settled, my lord, that there is no list, so to say, between me and, my lords, the respondent legislators. It is the duty of the speaker to find out if prohibited conduct under 10th schedule has happened.
It's more inquisitive.
Yes, my lord. If your lordship sees that I have dealt with, my lord, in paragraph 10, if your lordships are pleased to see the judgment in Mahachandra Prasad, it's a 3-judge bench. And I've quoted the relevant portion. The judgment is there in the latest compilation. The highlighted portion, my lord. There is no list between the person moving the petition and the member of the house who is alleged to have incurred a disqualification. It is not adversarial. Even if he withdraws the petition, it will make no difference as a duty is cast upon the chairman or the speaker.
That comment is
Yes, no.
in the context of that.
Of the 10th schedule. Yes.
The context of that. It's something
Correct.
like, it's something like a partition suit
Yes, no.
or a public interest.
Yes, no. Correct.
That if
Election
a party who has initiated it,
Yes.
loses interest, still
The speaker will
there
carry on.
is subsistent
Correct.
constitutional duty for the speaker to decide.
Lord, in fact, in Sharad Yadav's case,
Because you never know.
yes.
See, the beauty and the uniqueness of politics is beyond rational
That's right.
extension of possibilities.
Correct.
Because a person who moves the disqualification tomorrow may join the disqualifier.
That's true, my lord.
What happens then?
That's
Election
true.
appeals also, if the third parties do cut.
Correct, my lord. Also, my lord, in several cases,
I hope it is.
also in several cases, my lord, which have been upheld by this court, the speaker did not rely upon, my lord, the evidence adduced by the parties. He said, I have seen on TV.
On his own.
On his own. So that is, my lord, the duty of the speaker, because ultimately, as my lord, it was pointed out that the constitutional sin of defection, my lord, is something which, my lord, goes to the heart of our, my lord, democracy and the functioning of political parties. And speaker, my lord, being the custodian of the house, my lord, as a tribunal, he has a duty. That's, my lord, the point which I was making. Then, my lords, the other point in paragraph 12, which I have tried to address is, now, my lord, when the first set of petitions were filed on 21st, on the 23rd of June, and, my lords, on 27th of June, under para 21A, my lord, the factum of the government formation, which happened on the 30th, the vote of confidence and the speaker's election had not happened. So, my lord, we filed an additional affidavit. And that additional affidavit was objected to. And, my lord, speaker by a reasoned order, which, my lord, is there in my learned friend's submissions, which was handed over. It's a part of that page 19. My lord, granted an opportunity to the other side, took it on record, granted an opportunity to the other side to file a reply. And then, my lords, it was taken on record. Now, my lords, one of the questions which fell from the court was that whether the speaker can look at subsequent conduct after the filing of the disqualification, if it amounts to, my lord, a prohibited conduct. And the answer is yes. My lord, I have given two instances. If your lordships are pleased to see, my lord, Srimant Patil, my lord, here, paragraph 12. Paragraph 12, my lord. Some of the events the speaker took note of after the, my lord, disqualification petition had been filed, and speaker disqualified them, that was upheld. Lord, that I have cited in paragraph 12. Then, my lords, one more judgment, which, my lord, fell from the honorable court, was Sharad Yadav's judgment. And Sharad Yadav, that I have dealt with in paragraph 13, my lord, of my note. My lord, Sharad Yadav's case was a case where, my lord, after the disqualification order was passed by the speaker, Sharad Yadav joined a different political party. Question was whether in judicial review, my lord, whether that fact was a relevant fact or not. So really, my lord, that doesn't apply to our case, because all this is prior to the speaker's order. But there are certain important observations, my lord, in that order which actually completely support us. If your lordships are pleased to see paragraph 13, the quoted part, and any event or conduct of a person, even though subsequent to the passing of an order of the speaker or chairman, ordinarily may not be relevant for determining the validity of the order of the speaker or chairman. But in a case where subsequent event or conduct of the member is relevant with the state of affairs as pertaining to the time when the member has incurred disqualification, that subsequent event can be taken into consideration by the High Court. So and so has made very pertinent observation with regard to acceptance of evidence. If the court requires an evidence that can always be received, it was held that all procedure, etc. But ultimately for the purpose of granting relief, if the subsequent evidence is relevant, my lord, then the court will not shut out that evidence, is what the law is. And that is followed, my lord, in this 1975 judgment as well, which I have quoted. Now, my lords, one important thing, my lord, your lordship saw 175, that it is prima facie determination. And my lords, what is prima facie, my lord? We all know, my lord, I have cited that there is no deeper examination. You can't lead evidence. Prima facie, my lord, when the speaker is required to decide, he has to only go by what is there on the record of the ECI. And if on the record of the ECI, my lord, the political party structure is there, there is no question of going behind, my lord, that party structure under a prima facie determination. Now, my lords, there is a very important thing which I have, my lord, pointed out in paragraph 27, which really, my lord, goes to the heart of this case. And it is this. Now, my lord, I was appointed as the president, elected as the president in 2013. We contested, my lord, the 2014 Lok Sabha elections under my leadership. We had MPs. We had assembly elections in 2014, which were contested under my leadership. Then, my lord, several elections were fought between 2014 and 2018. In 2018, my lord, the fresh organizational election where I am again elected. And in 2019, my lord, leadership, under my leadership, elections were fought for the assembly and, my lords, the Lok Sabha. And, my lord, Mr. Eknath Shinde was elected on the symbol which was given by my party leadership. In 2022, my lord, one fine day on 21st of June, he decides to, my lord, move across the aisle and, my lord, join a different political party. And in doing so, my lord, he says, I am the political party. And the real constitutional question is that, my lord, when there is a political party, there is a leader and he has deputies. The deputy, my lord, sometimes is not happy. Question is whether he can straight away jump the aisle, commit prohibited conduct and say then that I am the political party, or is it constitutional, proper resort to change the structure of the leadership of the party. And, my lords, if that fails, he has paragraph 15, where he can effect the change in leadership. My lords, going and making, being a chief minister, my lord, is not so important compared to, my lords, the fact that if you are asserting political leadership, then you have to do it, my lord, first intra-party through the statutory mechanism of paragraph 15. And if you choose to, my lord, bypass this, then, my lords, the hammer has to fall under, my lords, paragraph 10 schedule. That's the submission, my lord, which I have tried to canvass in, my lords, paragraph 27. It is submitted that a harmonious reading of the provisions of the 10th schedule and paragraph 15 of the symbols order clearly outline the timelines procedure for any legislator who is dissatisfied with the existing party leadership and claims to represent the party to avoid losing his seat in the House. Any such legislator or group of legislature who claim to represent the original political party have to first establish and validate their claim in accordance with law before committing prohibited conduct. The course of action available to such faction includes calling for intra-party convention and effect a change in leadership by a majority support in the party. Arjun Singh says so, that before coming even to paragraph 15, you have to first sort out within yourself. And if I as the leader may not stop it, then you have a right to go under paragraph 15. If the faction in power opposes and precludes any action being taken by the rival group to assert its rights under A, the rival group can approach the civil court or the ECI for effecting a change in status quo of leadership. It is only after the leadership changes and is effected through a legal process, the rival faction can take political decisions. Question is, my lord, without effecting a change in the party structure can you take political decisions, which is prohibited conduct. The entire purpose of the 10th schedule, my lord, governs political conduct. What is correct political conduct, what is wrong political conduct. And that political conduct has reference to the political party. If you want to change the leadership of that political party and you want to claim that you want to represent that political party, then don't do the political prohibited conduct before effecting such change. And that is, my lord, something which your lordships may have to lay down. That, my lord, unless and until your claim as the party is established in accordance with law, committing this and then claiming in a para that in a 10th schedule proceeding that you are the political party completely, my lord, puts the 10th schedule, my lord, inversely, upside down, and which cannot be countenanced. And then, my lords, yes. Then, my lord, the next point, which, my lord, I briefly is C4, that there is a jurisprudential difference, my lord, between the 10th schedule and paragraph 15, which I have said, my lord, in paragraph 32. It is submitted that the process of adjudicating of a symbol dispute under paragraph 15 of the symbol order, the Election Commission has been empowered to confer upon a new status of being the political party. On the other hand, the prima facie determination of who the political party is under the 10th schedule is only an identification of the existing status at the time of defection. That is why, my lord, prima facie determination as to who is the political leadership. Then, my lords, as far as the perverse conclusions are concerned, my lord, Mr. Sibal has already pointed out, but just a few things on the 2018 constitution, which is very interesting, my lord, in paragraph 38. I just want to point out, my lord, some of this already been cited. Now, my lords, in serial number 4 of this, if your lordships are pleased to see, all the legislators, my lord, in the disqualification petitions filed the 2018 constitution clearly, my lord. Then, my lords, in evidence, we asked one of the legislator a question that, my lord, at page 15, one Mr. Dilip Lande. Witness is shown the index of his reply as well as annexure R1 to R18. Please refer to annexure R18, which is the 2018 constitution. In paragraph 2 of your affidavit, you state that you abide by the principles as enshrined in the Shiv Sena constitution. Are you referring to the Shiv Sena constitution annexed to your reply? He says yes, as submitted. Now, my lord, interestingly, kindly note the date, my lord, which is 7th of December. This is his cross-examination. Now, my lords, what happens on the 8th is another witness comes, my lords, on the 8th, which is, my lord, in paragraph 6, which is very interesting. And, my lords, this witness, before his cross, my lord, he says, kindly turn, my lord, I'll read that. It is submitted statement of Yogesh Kadam on 8th of December that filing of the 2018 amended constitution was a mistake of the lawyer, is a complete afterthought. In the chief, my lord, after the affidavits were filed, a question is asked, obviously to get over 7th of December. The respondent Yogesh Kadam filed his replies to the disqualification in August 22. On 25th October, Yogesh Kadam filed an additional reply containing detailed averments to 2018 constitution as well as the 99 party constitution. On 25th November, he filed his evidence but did not state anything relating to the 2018 amended constitution. The statement that annexure R18 was a mistake of the lawyer made by Yogesh Kadam on the very next day, 8th December, after the admission of Dilip Lande regarding annexure of R18. The fact that the witness made a statement even prior to the commencement of the examination in chief is recorded, my lord. Questions were not asked. He said, I made a mistake. I want to come and clarify. So obviously, my lord, it was all, my lord, reliance was thoroughly placed both in the Election Commission, Supreme Court, and in the Speaker. But to take advantage of that 174, 175, my lord, somehow this concept of 2018 lord, constitution was it. Then, my lords, the next heading only I'll read. Having accepted the relevant organizational structure, that is the 2018 structure, Speaker could not have, my lord, done an adjudication on that. Then, my lords, D3, the legislative majority in 133, 132, 144 is in the teeth of Subhash Desai. Then, my lords, D5. At page, my lord, 18, admittedly, no case of leadership structure by the respondents was set out outside the Legislative Assembly. And Subhash Desai is categorical, my lord, that you can't base your claim, even under a prima facie determination, to being the legislative party only on legislative majority. You have to show a structure outside the legislative, my lord, party, which was not done, which I have explained, my lord, in D5. Then, my lord, there is no dispute that I enjoyed clear majority in the leadership structure, my lord. That is in D6. I have given the details of the affidavits where, my lord, which were in our support, and the evidence as well in paragraph 66, my lord. So in our respectful submission, my lord, and then lastly, as far as the acts which constitute disqualification are concerned, my lord, these are admitted acts, as my learned friend pointed. More importantly, my lord, the fact that Mr. Shinde became a chief minister contrary to the wishes of the original political party. This is something, my lord, which does not require evidence. This is Lord, this is all in public domain. We filed an additional affidavit, my lord, on this, which I just alluded to. And the speaker, my lord, in the order says, I will not comment on the affidavit because I have held the Shinde faction to be the original political party. So, my lord, the facts are admitted that, my lord, these acts constitute disqualification. The only dispute was, my lord, whether who is the political party. And in my respectful submission, my lord, that inquiry on the validity of the structure of, my lord, the political party was an impermissible inquiry. At the most, my lord, what the Supreme Court said in 174, 175, do a prima facie determination. That is only seeing the records of the ECI. My lord, the speaker has no jurisdiction to change the record of the ECI, my lord, which is reflected on his website even today. The 2018 leadership structure is even today. But these are my broad submissions, my lord, as far as the, my lord, disqualification is concerned. But I have a few submissions left on the symbol dispute, my lord. Just give me some time tomorrow. I can finish.
No.
Half an hour, my lord.
Tomorrow?
Yes, my lord. Grateful for a patient here.